Hi, everyone. Thanks for joining us virtually. We wish that we could all be together in person, but we hope everyone is staying healthy. I'm Ann Oberndorf, and with me today is my partner in co-investment crime, Steve Boehm. We definitely miss being in person for this event. One thing that we miss the most is how interactive this session usually is, where you all can interrupt our ramblings with questions. Since you can't do that today, please feel free to contact either one of us directly if you have any questions after the session. We're going to touch on 4 topics today. We're going to give a brief background on co-investment. We're going to talk about if there are any changes in the co-investment world this past year. We're going to talk about changes we'd like to see, and then finally we'll touch on if there were any other interesting exemptive applications filed this year. So Steve, I know that you and I can talk all day, every day about co-investment relief.
And we usually do.
Yes, but why do our clients care about it?
Right. Well, this is for the new folks and a refresher for folks who've lived in this world. The reason we care about co-investment is that without SEC relief, most co-investment transactions can't be effected. Why? The essence of the 1940 Act is the prevention of overreaching by the promoters, usually the investment advisor, to 40 Act funds at the expense of the shareholders of the 40 Act fund. The prohibition on co-investment comes from Section 57A4, which prohibits so-called joint transactions. They really call it in the statute joint enterprises or arrangements, but effectively we call them joint transactions. What is a joint transaction? Joint transactions are not defined. In fact, the only court case that's addressed it has given us the helpful definition of a joint transaction is something that involves, quote, some element of combination, end quote. Not very helpful. What we do know is negotiated transactions involving a 40 Act company like a BDC on the one hand and an affiliated fund, either another BDC or a private company on the other hand, does implicate joint transactions because the negotiating factor is the one the SEC looks to in this situation. There is an exception, which Ann will mention, for negotiated transactions where price is not negotiated. But essentially, that's why we need co-investment relief. Ann?
Right, and just to dig a little deeper on that, as Steve mentioned, jointness is not really defined, but the staff is looking for negotiation. And negotiation obviously means if you're negotiating the terms of the transaction, such as the interest rate, but the staff interprets it even more broadly and takes the position that negotiation can mean voting on or signing a waiver, or withholding or giving consent to, for example, changes to the covenants of a loan document. Even further, even if one party is negotiating the terms of a transaction, such as the BDC, and the affiliated fund is staying passive, the staff has said in that case that that can still be a joint transaction. So this is really a broad topic that affects BDCs in their everyday world. Go ahead.
Can you talk a little bit about the application process and some of the timing factors that historically have been involved?
Sure, happy to. But before I get to that, I'm just going to give just a little bit more background. Steve, this is how Steve and I go back and forth all the time. There are 3 ways that a BDC could end up in a joint transaction with an affiliate. One of those is, and interestingly enough, only one of those is covered by the standard co-investment application. So the first way, which probably doesn't come up as often, is if the BDC and its affiliated fund invest separate in time. So for example, if they invest in the same issuer 2 years apart, nobody can claim that that's a joint transaction. In addition, as Steve referenced earlier, we have what are called mass mutual transactions, and that's if a BDC and its affiliate rely on the mass mutual no action letter issued by the staff. And in that case, if no other terms are negotiated other than price, the no action letter says that is not deemed to be a joint transaction. So in both of those cases, the BDC and its affiliate can get into the issuer, but the problem with both is that once they're in the name, if negotiation of terms of a transaction is required later on, such as for a follow-on investment, neither party can participate in those negotiations of the terms of that transaction. The co-investment order, that's the third way that you can have a BDC and its affiliate be in the same issuer, and that's the one way that they can negotiate the terms of a transaction if they entered into the investment in reliance on the order. And so when I talk about the co-investment order, I think most people are familiar with it, but when I talk about it, this picture is what I imagine. The relief has evolved over time, but the most basic model is that there is an investment advisor that advises a BDC and other funds, and the co-investment relief allows them to invest in a portfolio company. And that relief has expanded over time to include multiple BDCs and registered investment companies and different types of private funds and advisors under common control, et cetera. But this is really the basic picture. And there are two precedents that have arisen over time. There's the standard or older model, which has been around for ages. And then there's the newer or expanded model, which has been around since about 2016. I'm not going to go into detail about the differences today, though we'd be happy to discuss them offline. But what is the same about them is that they both have strict conditions. They have the two models have the same conditions, and the conditions are very clear on what you have to do a co-investment transaction. You have to meet all the applicable conditions, including that the board has to approve all initial co-investment transactions and most follow-ons and dispositions, although there are exceptions. What's interesting about the expanded model is that the difference I would like to point out is that in the two scenarios I just discussed, if the BDC and its affiliate invested in an issuer either separate in time or in reliance on MassMutual, under the old model of co-investment application, it would not help. The only way to use that model is if your first investment in the issuer is in reliance on the order. But under the newer model, there's a mechanism with board approval such that you can do a follow-on investment if you did not rely on the order to begin with and instead relied on MassMutual or invested separate in time. So that was just a little more background, and now I'll get back to your question, Steve, about the process for filing a co-investment application.
Right. Can you tell us a little bit about the process for those who haven't been involved in it, both in terms of how the staff reacts to it and the timing?
Definitely, and I'm sure many people are familiar, but just in case for those who are not, the first step, of course, is filing the application. And what you do is you find the precedent that most closely matches your facts, because when you file, the staff asks to see a red line marked against the precedent that you used, and they're very concerned with seeing as few changes as possible. Now, after you file, the staff used to have 120 days to review your application, and we'll talk about how that timing has changed. But they would typically take that whole time, give comments, and then the platform would revise their application in response to the comments and refile again. And that process would go back and forth until the staff signed off on the application. Then they would issue a notice, and typically 25 days after that, the order would be granted. Now, this process can be lengthy, but it does work. Over 100 co-investment orders have been granted to date, but it can be a frustrating process.
What's the average time that an applicant or applicants can expect the process to take?
So based on the process I just described, it typically can take from the initial filing to the time the notice is issued, it can take from about 4 to 9 months to up to years, depending on if you are within precedent or you're trying to change what's in precedent. And that's why it's important when you're filing to find a precedent that really matches your facts. But the timing has recently improved because the SEC adopted amendments that allow for expedited review of exemptive applications.
And exactly how does that work?
In short, if your application is considered routine, the staff will review it and issue a notice within 45 days, which is much faster than the process I just described. To give a little more detail, to be routine, the application has to be substantially similar to 2 other applications that received an order within the last 3 years. And substantially similar is defined as requesting relief from the same the same sections of the 1940 Act, containing identical terms and conditions, and differing only in terms of factual differences that are not material. There are a few other requirements related to requesting expedited review, but those are the main requirements. And the staff can issue comments or say that the application doesn't qualify for expedited review, but as long as you meet the requirements, they should issue the notice within 45 days. For applications that are not considered routine, they're considered novel, the staff is still trying to make the review process faster for those. So instead of taking 120 days to review the application, the staff is aiming to review these applications within 90 days for the initial filing and the first 3 amendments, and then any subsequent amendment they're trying to review within 60 days. So I think the staff is acknowledging that it might still be a lengthy process if it's a novel application, but they are trying to move through these applications faster.
Are people actually requesting the expedited review so far?
So the rule is relatively new. It went into effect in June of this year, but we have seen some applications filed. There was one co-investment application filed so far. There have not been 45 days have not passed since its filing, so we are definitely waiting to see if the notice is issued within 45 days, and that's how we'll know how the staff feels about co-investment applications. We have seen more movement in the multi-class application space. That's a different type of application that some of our partners will be discussing in a different session. But those applications are becoming more routine for registered investment companies. So we saw a registered investment company file a multi-class application requesting expedited review, and they received the notice in 16 days, which is just unbelievable to us. But then we did see a private BDC filed a multi-class application requesting expedited review. And we saw that they filed again, removing the request for expedited review and making other changes. So we don't know what happened there, but I think we can guess that the staff gave them comments and perhaps had them remove the expedited review request. So this is an interesting area, and we're definitely going to be following which types of applications receive expedited review, and hopefully that co-investment application will receive its request. Now, Steve, during this panel, we usually focus on changes to the co-investment world or precedent during the past year. I don't feel like we saw as many changes this past year. Why do you think that is?
I think the reason is relatively clear, and that is there's no leader right now in the Division of Investment Management. Dahlia Blast left as the administration changed late last year, and we're still waiting to see who the leadership will be. So not only are we waiting for a division director to be named, but when that division director is named, he or she will name a chief counsel, and the direction of the division, priorities, the workloads will all be determined once those 2 individuals are in place. So not surprisingly, there haven't been many breakthrough applications granted in the last 8 or 9 months.
Mm-hmm.
And one thing that has happened during the last 8 or 9 months is that there has been the renewal of some temporary relief, which has been positive for the industry. Can you talk about that a little bit?
Certainly. An area that has been frustrating for BDCs and their affiliates is how to treat a fund that didn't participate in the initial co-investment transaction, either because it didn't exist or because it didn't have capital at the time to participate. There is no co-investment precedent that allows for a fund that does not hold securities of the issuer to participate in a follow-on investment. Meaning that if you have a new fund on the platform and you have a lot of portfolio companies where you already completed a co-investment transaction, those new funds can never participate in a follow-on with regard to those portfolio companies, which is frustrating because, and take a small platform, if you have one BDC and we'll call it Private Fund 1, and Private Fund 1 is winding down and portfolio companies are requesting more money, Private Fund 2 now has capital and it cannot participate in the follow-ons, which means either the platform has to tell the portfolio company it can't provide money, or the BDC might end up investing more than is appropriate for the BDC. So this is an area where platforms have been talking to the SEC and trying to get relief, and that the staff has never been willing to make a change. However, last year, in light of the market volatility related to COVID-19, the staff finally did do something, and they granted the temporary relief in April of 2020 that was valid through December 31st, 2020, and it allowed private funds that do not have an investment in the issuer to participate in follow-on transactions with the BDC and other funds that had previously done a co-investment in the issuer. So that was very helpful, and otherwise the funds have to follow the conditions of the order like they normally would. The staff did add that where board approval is required for the follow-on, the board must approve the proposed follow-on both on a standalone basis and in relation to the total economic exposure of the BDC to the issuer. So if a new fund is participating, they have to make that additional finding. And just a quick picture of what that looks like. It's pretty clear, but so if you have BDC1 and Private Fund 1, then you can add in a second private fund, but you cannot add in a second BDC. The relief is only applicable to private funds. And now that relief expired in December of 2020, but in early January of 2021, the staff issued a public statement stating that the SEC would not recommend enforcement action if platforms continued to rely on this relief through March 31st, 2021. And then in early March of 2021, they again extended that position through March 31st, 2022. So platforms have been relying on this relief and are able to continue to do so through March 31st of next year. Steve, do you have any thoughts on if this relief will be extended again or become permanent?
Well, you have to believe that eventually it will become permanent in some form. First of all, the fact that the staff has extended it a couple of times suggests that they haven't seen any abuses. Given the lack of abuses and the salutary results for BDCs and their ability to make investments they might not otherwise be able to make, you have to think the staff is going to extend it either by a permanent rulemaking or perhaps more likely by allowing it in typical exemptive applications. And in fact, I think there are 4 exemptive applications that have been filed in which a request has been made to be able to co-invest on this basis. So I think it's here to stay. The form in which it will take, I think, is to be determined.
I agree. I think that, if they grant one of those orders, then everybody's going to file requesting the same relief and the staff will be inundated. So they might as well just make it permanent.
Now, our theme has been that there haven't been a lot of fundamental changes in the type of relief that's been granted, but there have been a few. Can you highlight those that have been made in the past year?
Definitely. So, as we've discussed, that there really have not been many changes this past year, and the 2 we're going to talk about are minor, I have to admit. But there was a change to the definition of proprietary accounts and the re-emergence of the CLO footnote, which I'll describe in a minute. But proprietary accounts, just to give some background, as I mentioned earlier, when co-investment relief was a newer thing, it really only applied to the BDC and its affiliated funds. Over time, advisors were added to the co-investment application, and they were the advisor and the accounts that it owned. If they wanted to participate in co-investment transactions, they had to be added to the application, and they were referred to as proprietary accounts. At first, proprietary accounts had to go last, meaning that they could only participate in a co-investment transaction if the BDC and all the other funds on the platform received the allocation that they desired. And if there was leftover, then the proprietary accounts could participate. Over time, that requirement went away, and now proprietary accounts are treated the same way as all other private funds. Now, proprietary account is typically defined as the advisor and any wholly or majority owned subsidiary of the advisor participating directly in the transaction. And this year we saw a few orders granted where proprietary account was defined as the advisor or its affiliates, or any majority or wholly owned sub of the advisor or its affiliates. So it's a small change, but it broadens the definition a little and can include employees of the advisor or control persons of the advisors. So again, a small change, but might be worth making to your application if you're in the middle of filing. The other change, that not really a change, but something we're seeing again, is what we call the CLO footnote. And to explain that, I'm going to give a little bit of background. Another issue that we see on platforms is what happens if a private fund sells securities acquired in a co-investment transaction to another private fund. This is not addressed in the application specifically, and I don't think a lot of people even realize that it could be an issue. But it comes up in a few ways. And Steve, do you want to talk about one of the main ways we see it come up?
Right. One of the main ways that the issue arises is in the context of so-called season and sell transactions. For offshore funds, if they want to acquire originated loans, there has to be a period of time between the time the loan was originated and the time they acquired the loan. Otherwise, they're deemed to be involved in a U.S. trade or business and charged with ECI, or effectively connected income. In order to avoid that, a onshore entity has to season the investment before it can be sold or transferred to the offshore investment. The period of seasoning varies on the law firm whose tax opinion you're requesting, But this is an issue that is not uncommon in the context of platforms that have both onshore and offshore funds.
Right. And so, you know, in these scenarios, we brought it up with the staff a few years ago. The staff, it's not even, I mean, if you read the conditions of the order, once a security is sold to the private fund did not acquire it in a co-investment transaction. So the staff takes the position that the acquiring fund cannot participate in any negotiated follow-ons or dispositions, meaning they can't rely on the order because they did not acquire their securities of the issuer in a co-investment transaction, which is obviously a frustrating result. And we think the reason the staff takes this position and drafted the application this way is because they don't want the affiliated fund, the acquiring fund, getting a first look at the security, meaning that they get to see how the security is performing. Whereas when the BDC is investing, it does not know how the security is going to perform, and they think that's unfair to the BDC. This is a frustrating position, number one, because this comes up in the industry a lot in different ways, and it's a problem not to be able to have these acquiring funds participate in follow-ons. But also because the temporary relief that we just discussed, that allows private funds that do not hold an investment to participate in a follow-on, but it does not apply to funds that do have an investment that was not acquired in a co-investment transaction to participate in a follow-on investment. So it's a little frustrating, but one area where the staff has gotten comfortable is with regard to CLO warehousing. And briefly, that is when for CLOs, our understanding is that one fund purchases the securities and holds them, and then they sell them to another fund, which will become the CLO. And so, of course, in that situation, you're having the sale of securities from one fund to another, and those securities typically are acquired in co-investment transactions. So this came up for us a few years ago, and the staff did allow a footnote to be added to the application for this one scenario, basically saying that after the sale, the CLO that acquired the securities would be treated as if it acquired those securities in a co-investment transaction and therefore could continue to rely on the order. Why are we bringing this up now and going through this whole explanation? Because this year, that was a few years ago. I have not seen the footnote very much since then. This year we saw it in, I think, about 3 applications that received orders. And so I think it means that we just thought it was worth noting. I think it means the staff is still focused on this. They revised the footnote. I've included it on the slide. I'm not going to read the whole thing, but basically making it clear that the sale will be treated as a disposition under the order and that the acquiring fund can continue to rely on the order. But we're curious if this is something the staff is thinking about again, and maybe we can bring up those other areas as well, and that's something, especially given the temporary order, that they would be willing to consider. So definitely something to think about.
And that's a good description of what's happened this year, although on a relatively limited basis. What's on our wish list for the new administration?
Well, first, I just want to say that this would be a nice time to be interrupted by the audience with a question. I've been talking for a long time, but I'll keep going. I think there are a number of things, obviously, that we'd want to see addressed, but the 2 main things are related to sub-advisor relief and, of course, the world-changing FS application that Steve mentioned earlier. So with regard to sub-advisor relief, just to give a background there, it is common for a fund outside of the platform to hire another platform with expertise to sub-advise the fund. So if you look at this picture I just pulled up, this is the standard platform I was discussing earlier, and then you have a fund in gray that is outside of the platform with its own advisor that is unaffiliated with the platform, the original platform. And so typically this gray fund and advisor would hire the green advisor to sub-advise it. In order to have this covered by co-investment relief, because of course the point is that this unaffiliated fund would like to co-invest with the platform it is being sub-advised by, to have that covered by the co-investment order, you have to add the fund and its unaffiliated advisor to the application, and they have to sign and comply with the conditions applicable to them. This is obviously a pain because, as we talked about, the application review process can take a long time. So if a platform is trying to set up an arrangement to sub-advise a fund, and they also have to go through the burden of getting a new co-investment application, that can really be a pain. But this is how things were for a while. And then in 2019, there were about 3 applications that received an order where the language related to sub-advisors was different, and it was a little more ambiguous, and it was being interpreted to mean that you did not have to name the fund you were sub-advising and its unaffiliated advisor on your application, and meaning that you would not have to go back into the SEC every time you entered into a new sub-advisory arrangement. And we thought that was a great development. But then I think the staff realized they had opened the door too far. And of course that happened with us. We had an application on file with that language, and the staff came to us and had us change it. And they basically went back to the old position. And if you look at more recent precedent, there's, it's very clear that sub-advised funds and their advisors have to be named. And so I think, the point there is we would like to see the sub-advisory relief brought in. We think that, it can be inferred that the unnamed, unaffiliated advisor would comply with the conditions applicable to it, and it doesn't have to be named every time, because it is such a burden to have to go through that process every time. The other issue related to sub-advisor relief is with regard to multi-manager funds. As you can see in this complicated picture, a multi-manager fund is basically a fund that is split up into sleeves. And the point is that each sleeve is going to typically focus on a different type of security. And therefore, they want to retain a sub-advisor that also has an expertise in that type of security. So for example, in this picture, there's a platform A that already has a co-investment order, and it's going to sub-advise sleeve A. And there's a platform C that has an order and is going to sub-advise sleeve C, and so on. Now, each platform would have to amend their order, as I just discussed. They'd have to amend their order to say that they're sub-advising their sleeve and list the investment advisor to the sleeve on their application. So for example, platform A would add sleeve A, and it would also add the advisor to the whole multi-managed fund, which is advisor B. This staff has not granted this relief to date. Each platform would have to go through this process. We know there have been conversations with the staff, and there have been at least one application filed. And I think the argument there is that each sleeve would be treated as its own fund, so it really should not be a big deal. It should be just a separate fund being sub-advised. But I think the staff so far has not been comfortable with one fund being split up amongst different co-investment platforms. And I think, maybe when we have a new administration in place, hopefully we'll see some movement there. And then I think everyone would like to see the FS application granted. Steve, do you want to talk a little bit about that?
Right. This is the holy grail of co-investment. Back in 2018, the SEC thought it would be a good idea to develop a no-action position that would allow co-investment without having the board's role continuing. The board, as you probably know, is required to approve all co-investments except where you have a follow-on or a disposition done on a pro rata basis. What the FS, what the no-action position would do would be to move the responsibility for co-investment approval to the advisor, with the board assuming a supervisory role and making sure the policies and the procedures for the co-investment are being followed, and they would do that on a quarterly basis. In 2019, Franklin Square actually filed an application, not a no action letter, but an application to that effect, hoping to simplify the co-investment process, particularly in terms of the board's role. There have been fits and starts since then. Shortly after the 2019 filing, the staff indicated that it was dead on arrival and they were not going to grant that relief. Since then, there have been whispers from the staff that maybe, just maybe, this approach will survive in some form going forward into the future and will be implemented. At this point, we have no way of knowing whether the new administration, when it's in place, would actually support this, but it's something that the entire industry would benefit from in terms of a simplification of the processes. So we're waiting with bated breath to see whether this has any life, whether it's on life support or whether it's in the ground and done. We are keeping our fingers crossed, and we will raise it with the new administration to make sure at least they're considering it.
Mm-hmm. And Steve, since I've talked for most of this presentation, I'm going to ask you a few questions now that we have a few minutes left.
Please.
Were there any other types of applications filed this year that you think everyone would be interested in hearing about?
Yeah, there are two types of applications that I want to mention. The first is 12D3 applications. 12D3, as you probably know, prohibits a BDC from owning interests in an investment advisor. Rule 12D(3)(1) under that statutory provision allows BDCs to own up to 5% of the equity and 10% of the debt of an underlying investment advisor. The SEC has been reluctant to grant relief under 12D(3) other than to internally managed BDCs, where they've granted it in a few cases to permit such internally managed BDCs to establish a broker-dealer, an investment advisor, for the purpose of advising third parties. And Main Street has that in place, and Hercules has it in place. Interestingly, Hercules recently got a no-action letter to allow them to implement a wholly owned investment advisor. However, the SEC has turned that into an exemptive application process. They've indicated that they will no longer grant no action letters for reasons we don't quite understand, but rather exemptive orders will be required. The good news is they will be granting those orders the best we can tell, so that if you're an internally managed BDC, you'll have a good opportunity to add an investment advisor to your structure. Now, there is another type of 12D(3) relief that has been sought, and that is to permit a BDC to invest in numerous investment advisors, but not for control, rather as an investment. The staff has insisted in those cases that a very narrow precedent called cantilever, be followed in order for that relief to be granted. Among other things, cantilever requires that the investment in the underlying investment advisor be debt, not equity, and that the BDC have a very limited role, if any, in the management of underlying investment advisors. So we'll see how that develops going forward. The other and perhaps most interesting development in exemptive orders this year was the filing of an application by Blackstone to permit the investment advisor to a BDC to receive its compensation in the form of shares. Now, this structure cuts against the very biblical commandment of Section 23A1 that 40 Act companies, including BDCs, not issue shares for anything other than cash or other securities. When you look at the application, there is no precedent cited, not surprisingly, but rather the application goes into the policy reasons why it would be appropriate, including the fact that by giving the advisor shares of the BDC, it's aligning its interests with the shareholders of the BDC. This is one to watch closely. It's unclear to us whether this was discussed with the staff before the filing or it just came in cold. But we'll be watching this very carefully because it would have great implications, not only for the relationship between investment advisors and BDCs, but I think more broadly on the ability to issue shares for services.
Right, and we'll definitely be watching that. And actually, I think that was the only question I have for you.
Oh, geez. Oh, well. Well, Anne, unless you have anything else, I want to thank our audience for their tuning in today. We're very, very sorry we can't see you in person, but we're looking forward to seeing everyone in January at our in-person continuation of this year's BDC Roundtable. And again, if you have questions raised by anything we discussed today or any other co-investment issues you have, please feel free to reach out to Anne or me, and we'd be happy to address your questions. Thanks very much.
Thank you.